Hello and welcome everybody to Chapter 6, School Personnel and School District Liability. Some general information concerning this matter. It should be noted that teachers and administrators are held to a higher standard of care than the ordinary man on the street. The teacher or administrator is under the duty to possess more than the ordinary amount of intelligence in relation to students in their care. So given that teachers and administrators are held to a higher standard than most, when they receive their teaching certificate and sign their contract at their district, a code of conduct must be met, which means they will fulfill all legal duties. So that is whether they are educating students in meeting state standards or just the overall protection of the students. The school as a safe place. Now, schools are presumed to be safe places where teachers teach and students learn. The prevailing view held by the courts is that prudent professional educators acting in place of parents are supervising students under their care and ensuring to the greatest extent possible that they are safe. So this doctrine is designed, should be providing parents with such assurance that their children are safe under the supervision of professionals. So per our school law and public schools handbook, educators have been assigned 3 legal duties by courts under the terminology of in loco parentis, which means in place of parents to instruct, supervise, and provide safety of students. In loco parentis places an obligation on all certified personnel to take necessary measures that the environment at the school is safe and conducive for students. There's a couple cases that kind of present this matter. Hoseman versus Oakland Unified School District case is the California Supreme Court judge ruled that the Oakland Public Schools have the duty to reduce crime and violence on school campuses. And this case involved 2 students which were involved in assault and theft. The ruling represented that the court interpreted a state constitutional amendment that grants students and staff the right to attend campuses that are safe, secure, and crime-free. We know administrators are held at a higher standard due to the notion that they're in charge of not having just one class, but the entire student body. So staff need to be instructed to keep administration in the loop concerning all discipline acts. It's also pertinent that administration is present throughout the school. Are they available for recess duty? Are they walking in the halls? Are they checking in the classrooms? Are they making sure that they are available at lunch so that they are aware of what is going on around them at all times? Slide 4 is the liability of school personnel. School personnel are responsible for their own torturous acts in the school environment. Liability involving school personnel normally falls into two categories. We have intentional torts and unintentional, which we'll talk about here in a little bit. But blame or false accusations cannot be made when an incident occurs. So we know that things happen. There are some things that we do not see, but as professionals, it's our duty to own up and handle the repercussions as an adult should. Now, intentional torts, such as assault, battery, libel, slander, defamation, false arrest, malicious prosecution, and invasion of privacy require proof of intent or willfulness, whereas simple negligence as unintentional tort does not require such proof of intent or willfulness. So I'm going to kind of go into both the intentional and the unintentional just to break them apart a little bit for you. And to backtrack just a little bit farther, a tort is an act that causes harm. So an intentional tort is knowingly and purposely causing harm. The difference between assault and battery, which most of us know, but I want us to review a little bit. Assault is more of a threat, whereas someone charged with battery could have been causing real physical harm to somebody. Libel versus slander defamation. Libel is the written form, where slander is oral. So both have gotten increasingly worse, obviously, due to social media. Now, unintentional tort, as mentioned above, is negligence, which occurs most often that we see in schools. There's a situation that we had this past year at my district where we've had, and our principal is coming from an urban area, and we are a very rural school. So he was amping the safety up a little bit. And like I said, given we probably have maybe 100 students in our school, and there are 2 grades usually at recess at one time. And he always makes sure that we have 2 people on staff watching at recess. Well, there were times that we would have paras looking down at their phones. Well, thinking about just kind of the negligence there. If they're looking down at their phone for whatever the reason may be, even if it's a secretary texting them and somebody falls from the monkey bars, that right there could be a problem of negligence where we were not watching what was happening. Thank goodness we have cameras for that. But it's important to understand individual liability because one may be held accountable for actions that result in the injury of a student. So normally this occurs when the plaintiff can provide evidence that an employee violated the law or right of the plaintiff. Now, getting into vicarious liability is a little bit tricky. Since school districts are deemed employers of teachers, they may also be held vicariously liable for the negligent behavior of their employees. So per our law book, the board rather than the principal is held liable for the acts of the teachers, even though the board is not the ones at fault. So under the old theory of respondeat superior, the master is only responsible for authorized acts of its servants or agents. So this is most prevalent in cases involving negligence where a class action suits are made against the school district for the negligence of the teacher.
So now moving into foreseeability. Foreseeability is a crucial element in liability cases, especially in cases involving negligence. Foreseeability is defined as the teacher's or administrator's ability to predict or anticipate that a certain activity or situation may prove harmful to students. And then it is the expectation that teachers and administrators can predict and are expected to foresee potential danger when it comes to activities or conditions within the classrooms or the schools. This goes for all teachers and administrators. So if you're in your classroom and you think that there's something that's going to happen within the classroom that's going to prove harm to students, you have to do your due diligence and make sure that that action or whatever may cause that is taken care of. And then once this determination is made, there's an expectation that prudent steps be taken to prevent harm to students, and then failure to act prudently may result in liability claims against you or the school in some way. An example of this, I was kind of thinking about foreseeability that I kind of constantly deal with that I really didn't know I dealt with is how to particularly group students in regard to seating. So if you put 2 behavioral students that have behavioral problems together, you didn't do your due diligence when it comes to foreseeability because you group those two kids together, and it could possibly cause harm to them or distraction to other kids as well in school, in the classroom. Now moving on to assault. And assault is an offer to use force in a hostile manner, which causes apprehension. The person being assaulted normally must feel a degree of immediacy in the sense that the one committing the assault will execute it promptly and has the apparent capacity to do so. Assault involves any threat to inflict harm to another person's body in an offensive manner. It is very important to understand that assault can be verbal or exhibited through actions. Something with assault that some people may not know is no physical injury is necessary. It can just be based on the mere fear for personal safety to be established as an assault. Now, battery is the second part of that. A battery has occurred when a physical contact actually takes place. In practice, a battery is a successful assault. A battery involves unwelcome and unprivileged body contact involving another person that is hostile and unlawful. Something to realize is usually battery and assault are combined when charges are brought up against an individual because assault normally precedes battery. And then assault and battery affects teachers, administrators, and students in the school environment. Every person is responsible for his or her actions in cases involving assault and battery. And then teachers and administrators are responsible, For foreseeability, when it comes to battery and assault, if they experience a student being assaulted and battered, they must take the proper steps to prevent injury if they fail to do so, so that they can be held liable. Most commonly, school personnel are charged with assault and battery when there is evidence that they administered corporal punishment with malice and excessive force. So while I was kind of putting my part of the presentation together yesterday, our superintendent came into the library while I was working, and he started talking about how with foreseeability, like it's the due diligence and battery and assault, it's the teacher's due diligence to make sure that whatever they see, they report it to administrators. So that's a principal, assistant principal, superintendent. And then he kind of said, now that was on his plate, he just simply relays that message to their school attorney, just to make sure that all their bases are covered in that sense.
And one part, Alex, that I want to put into there, I was talking with our SPED director yesterday, and she said it is so important if there are cases involving the students with the IEP to not only let the resource teacher know, but also the SPED director know. Like in my district, we have 4 buildings, so she's not always in the building at that time, but to always let them know as well for liability reasons.
Yep. Kind of moving the responsibility off of your plate to the next person's plate until it reaches the correct person, I guess. All right, now moving into defamation. So defamation occurs when false statements are made about another person. These statements generally are ones that tend to harm a person's good name, reputation, or subject the person to hatred, contempt, or ridicule. And then 2 common forms of defamation are libel and slander. And certain statements are privileged if in good faith for educators and within the scope of educators' duty. And then, therefore, school personnel who expect to be protected by qualified privilege must not make false statements regarding students or colleagues with malice or the intent to harm. So, as educators and administrators, we kind of have a privilege where if we make a comment about a student to another teacher or administrator or anybody else in the building for the good of their education, that's not necessarily going to be defamation. But if you're just something that I kind of thought of when you're in the teacher's lounge talking to teachers about a kid or another faculty member, another teacher, you could probably hear some sort of defamation occur to spread rumors about students and colleagues. I don't know about anybody else. I kind of hear that sometimes when you're in the teacher's lounge at lunch and you hear someone talking about another kid. It's like, I don't know if we should be talking about that right now. There's other people here. So I don't know your guys' 2 cents on that.
Unfortunately, I think it happens every day in every school across America. I mean, it happens in my school every day. And it's nice to know that there's a word for that the next time I come across a conversation like that.
Well, and I think we as building leaders and ourselves, it's our responsibility to step up and stop the conversation.
Yeah.
All right, libel and slander. Libel is a written defamation, whereas slander is considered to be oral, like we discussed before. Both use statements or communication that result in an injury to a person's reputation, good name, or standing in the school and community. And privilege is really, educators have some freedom in making statements within their duty, but they must act in good faith without personal spite. So, even if your feelings get a little hurt when you have a parent conflict or a student conflict, you have to rise above and be on a pillar. Good faith is educators need to act in good faith when making statements within their official duties based on reasonable grounds and without ill will. And truth is a defense against defamation if statements are made in good faith and believed to be accurate, but malice can negate this defense. A third party must be privileged to this communication to establish defamation. The burden of proof rests with the person who claims injury based on defamatory statements. Mental distress, charges of mental distress may arise from conduct causing serious emotional distress, such as unreasonable disciplinary actions by a school personnel. Disciplinary actions could be school personnel can discipline students reasonably, but actions causing embarrassment or humiliation may lead to mental distress charges if deemed unreasonable. I know that it's been recommended that if you need to have a verbal discipline or conversation that you pull a student off to the side or in the hallway and not have those in front of the entire student body in the classroom.
Agreed.
False imprisonment. False imprisonment occurs when a student is detained illegally by the teacher or principal.
Whoops.
That's okay. False imprisonment is considered to be an intentional tort. So school personnel must have a valid reason for confining a student, and the confinement should be considered reasonable to avoid false imprisonment, which is an intentional tort. Teachers and administrators can detain students for disciplinary reasons, but should follow school or district policies to prevent wrongful detention. In a case in Virginia involving a student accused of bringing a gun to school, highlighted the balance between student rights and school safety, with the court ruling in favor of the school's officials' actions. Despite claims of lack of parental notification during the detention process, the court upheld the decision, emphasizing the school's responsibility to maintain order and a safe environment. The legal standards set by the U.S. Supreme Court were referenced to justify the detention of the student based on reasonable grounds and the seriousness of the alleged offense. Unintentional torts. An unintentional tort is the wrong perpetrated by someone who fails to exercise that degree of care in doing what is otherwise permissible, acts of neglect. Unintentional torts can occur when someone acts negligently by failing to exercise proper care, often leading to injury. Negligence is a common issue in school involving a failure to meet reasonable standard of care, resulting in harm to individuals. I can think of a time we had to safely restrain. The people involved had training. We had to restrain a child due to possible injury to themselves and to others. And in doing so, putting the child down to a safe place, the child kicked and actually got the corner of the doorway and just gave herself a bruise. But that would be a case of possible negligence. Negligence is generally viewed as the failure to exercise a reasonable standard of care, which results in harm or injury to another person. Most negligent cases involve civil wrongs, although there may be instances in which the accused faces both civil and criminal charges. Cases of negligence in school often involve teachers, principals, and boards of education, with defendants being released if not significantly involved in the injury. To prove charges of negligence, a student must establish 4 key elements. 1 is standard of care, 2 is breach of duty, 3, proximate cause, and 4 is an actual injury. Wanton negligence, like violations of traffic laws causing harm, can lead to criminal charges in addition to civil cases.
Something to kind of go off of the negligence part in those 4 aspects in terms of what I kind of see in our school system is we kind of as teachers are in charge of kind of hallway duty and monitoring the hallway in between passing periods. And then we kind of huddle in kind of an area, we watch the hallways, but then the bell rings and then some of us or some people stay out there for a minute and a half after, and then we get into our rooms. Okay, that would be, I think, an example of breach of duty, where we're not in the classroom when we're supposed to be, and something could happen there, and then that would when a case of negligence could be brought up.
Alex, you're reading my mind because that was exactly what I was thinking. That was one thing that our administrator reiterated. Like I said, coming from a rural school, if we needed to run out of the room really quick to go grab something, oh, it'll take 2 seconds to go and do that. Well, in those 2 seconds, a student could get out of their desk, could take off running, hit the edge of something, and then right there, we've got that liability. So yeah, it's very important to be present at all times.
Yeah.
Tell you what, group, as I read this chapter and listening to everyone present, it just brings up all the things that I'm doing wrong and can be better at.
Yeah.
Good
All the
reflection.
mistakes that I have made, and luckily I've been lucky in that nothing's happened, but I got to be better.
Yeah.
Yeah, Nathan, I'm with you. Good reflection for us all.
Yeah, only takes a second.
Mhm.
Standard of care. Standard of care is an important concept in cases involving liability and school personnel. It requires that school personnel exercise the same degree of care in which a person of ordinary prudence would exercise under the same similar conditions. So a standard of care is the school personnel must exercise the same level of care as other people in similar situations, considering factors like age and nature of activities. The standard of care might be different for a teacher inside the classroom versus a coach out on the football field. Differences in care. Standards may vary based on student age, maturity, and activity type. Higher care levels for younger students or risky activities like chemistry labs. Even if you think about if you have, you're in a level 3 classroom, students typically in a level 3 classroom lack skills and behavior, being able to determine appropriate behaviors, appropriate verbal language, those types of things. Educator responsibility is educators have a duty to supervise students adequately, considering students' maturity levels with a higher standard of care than adults. The standard of care will be vary depending on the particular circumstances. We talked a little bit about the age, maturity, experience, and mental capacity of students. Legal standards, state law differs on care standards for educators, ranging from that of reasonable parent to willful misconduct. Case study is failure to meet the care standards, which can lead to liability, as seen in the case where inadequate supervision resulted in student harm. Breach of duty is when educators are expected to foresee possible harm and take prudent steps to prevent it. Failure to do so constitutes a breach of duty. Proximate cause. Injury must directly result from an educator's failure to act prudently. Courts consider the direct link between negligence and injury. And then finally, injury and liability. Liability exists when actual injury occurs to school personnel's actions or negligence. Compensatory damages may be awarded.
Okay, so I'm going to discuss defenses for negligence, and the first one we're getting into is going to be contributory negligence. And so this is the most common defense used in charges of negligence. There's a common law presumption regarding the incapacity of students to be contemporary negligent. They're the following. So if you are less than 7 years old, you cannot be charged with contemporary negligence. If you're between the ages of 7 to 14, the reasonable assumption is that they are incapable of contemporary negligence. But if you're older than 14, it may be assumed to be contemporary negligent, depending on the facts surrounding the injury. However, these are not absolute, and they only serve as guides along with the actions of school personnel. It also, other factors are the intelligence of the student or students involved and the level of maturity. Now, a key question that must be answered is, did the student act as any other reasonable or prudent student of similar intelligence and maturity would have in the same situation? Now, when we talk about next, we're going to get into assumption of risk. Now, assumption of risk is commonly used as a defense in situations involving various types of contact-related activities, such as athletic teams, pep squads, and certain intramural activities. However, even though the theory is that students assume an element of risk to participate from the activity in which they wish to participate, they have the knowledge and an understanding of the potential damage involved in participating in the activity. However, even though a student assumes an element of risk, that does not relieve school personnel from when they fail to meet a reasonable standard of care based on the age, maturity, risk, and the nature of the risk associated with the activity. In assumption of risk cases, it must be established that the informed student know of the risk and voluntarily chose to participate. School personnel are expected to exercise prudence and to reasonably foresee that injury could result. based on either a lack of proper supervision, an absence of reasonable supervision, or an improper decision regarding the injured student. Assumption of risk does not relieve school personnel of executing their duty to instruct, supervise, and provide safety of students under their supervision. And there was a fantastic example from the book, I believe it involved a boy named Morris who got the custodian of a school to let them in to the school building to play basketball with some of his friends. And the school custodian let him in and went about his business as custodian, did not supervise the students in the gym, and an injury did occur. Now, it was an injury that would have happened it wasn't due to a lack of supervision, but that definitely put the school in a very compromising situation. Now let's talk about comparative negligence. Now, under comparative negligence, acts of those responsible are compared in the degree of negligence attributed in an injury situation. Now, this is a relatively new concept and has grown in popularity in many states. Under comparative negligence, acts of those responsible are compared in the degree of negligence in an injury situation. Now, juries will determine the degree of negligence, and they will range from slight to ordinary to gross, depending on the circumstances. Now, this does not prevent recovery by the injured party, but merely reduces the damages based on the fault of the injured parties. Now, if the jury determines that both parties, through their acts, contributed equally to the injury, then neither party is assessed damages. Comparative negligence has become increasingly popular in school settings because of the growing tendency of state legislatures to adopt it as a legal concept. It is considered by many legal experts to be the fairest method of assessing liability because it places responsibility on both or all parties and degrees of fault exhibited by each party involved in the injury. So basically, with comparative negligence, the juries will decide who's most at fault and who's least at fault, and then give compensation out that way. And then that'll take us into immunity. Immunity is a legal concept, has diminished in terms of impact. It's based on the old common law of sovereign immunity. The king can do no wrong, meaning that the state or federal government is protected from suit and cannot be held liable for injuries that resulted in the proper execution of governmental functions. So some states have school board immunity, but others recognize the concept based on whether an activity is classified as governmental or proprietary. Some courts have waived immunity by school boards who have acquired liability insurance. And that's chapter 6, school personnel and school district liability.